2019. And for the record, Councilmember Pond, Councilmember Davis, and Councilmember Weaver will not be with us tonight. Otherwise, we have a seated council. Thank you all for being here. Our first item on our agenda is a public comment for 3 minutes on any item on the agenda. I have a sign-up sheet, and then I will read your name. When I read your name, you come to the podium and adjust the microphone so it suits you and we can hear you. And give us your name and last name, and spell your last name if you would, and give us your address. And we will start with Rachel Hulteen.
Good evening, Mayor and Council. My name is Rachel Hulteen, Hultin, and I live at 4690 Balsam Street. And it's an empty table tonight. So I'm here this evening just to provide a little bit of comment on agenda item number 2. And I was excited to see that looking at a suite of options for rezoning hearings is on the study session tonight. I had been in here about a month ago proposing some different ways of approaching when there's a protest to a rezoning and triggering a supermajority vote by council for the approval of the rezoning. And I brought that idea forward in part because what I've been hearing again and again in this room over the last, particularly in the last year, but I think, in different forms since I've been coming here, is that we want our processes to be more predictable, more transparent, and we want to make sure our community is informed of actually what's happening and what situations are. And our charter gives the citizens the right to protest a zoning application, and they can submit that as soon as just a couple hours before the hearing. And there's a good reason we have that right in our charter. However, that changes the dynamic in the room and the reality of what that rezoning hearing is. And I think it's really only fair to our citizens, to our city councilor people, to the people who are bringing their great ideas to our city, and to everyone involved in making good decisions about the future of our city, to not be caught off guard and surprised, to find out at the hearing that it's been protested and requires a supermajority vote, really can put people on edge. I think it heightens some of the sensitivity and awareness to the materials. I think it might change some of the questions. And I think our citizens might have different viewpoints or different perspectives. So I'm encouraging, as you guys discuss this matter tonight, to seriously consider adopting an ordinance that would automatically postpone a rezoning hearing to the next city council meeting in the event that there's a protest triggering a supermajority. I think that is fair to everyone in the room. I think it's fair to our citizens, and it doesn't ultimately change the information that's available about the project itself, but it certainly changes the opportunity for the citizens of our city to know and understand what the situation is, what the concerns are of their fellow citizens, and to have an opportunity for their voices to be heard at the hearing. So I encourage you to consider option 3. And I'm eager always to hear how you guys are doing more to engage the citizens of Wheat Ridge. Thank you.
Thank you. That's the only speaker I had signed up to speak. Is there anyone here who is not signed up who would like to speak tonight under public comment on any item on the agenda? You may come forth now and talk. Okay, we will complete our public comment and go into agenda item number 1, the creation of a city ethics code. And I believe our city attorney, Mr. Dahl, is going to lead us through this item. Mr. Dahl?
Yes, thank you. That's a live mic there. Back that up just a little bit. The voters of Colorado adopted an amendment to the Colorado Constitution, Amendment 41 in 2006, and it created this independent ethics commission charged with enforcing ethics in government. Now, Colorado's had a ethics in government statute for a long time, which is more or less mirrored in some ways by the constitutional provision, but you pay more attention when it's constitutional provision because it absolutely applies to local governments, including the city. I've summarized Amendment 41 for you and made a couple of, I think, key points. What is important to remember about Amendment 41 is that it puts jurisdiction in the Independent Ethics Commission, which is a state-level commission appointed, I think, by the governor. I'm not certain if there's a Senate confirmation, but that commission is charged with enforcing conflicts of interest, the appearance of impropriety, and post-government employment, kind of the revolving door issue. The U.S. Congress occasionally struggles with revolving door and doesn't seem to make a lot of progress with that. But that's what the Independent Ethics Commission has jurisdiction of. And for a while, it was pretty quiet, really, other than some complaints filed against the governor for the governor's use of the funds, et cetera, and distinguishing between whether the governor was using those funds in his official capacity or for campaign purposes. But this issue was brought to local government and especially Home Rule City's attention by a case in Glendale, which I have described for you. There was a complaint filed against the mayor of Glendale by citizens, and they filed that at the Independent Ethics Commission. And Glendale said, well, we're a Home Rule City, and the constitutional provision specifically says Home Rule cities, to the extent they adopt local rules by charter or ordinance covering, quote, the topics addressed by the amendment, are exempt from the amendment, exempt from the jurisdiction of the Independent Ethics Commission, and instead may run their own show ethically in terms of how they set up the rules and how those rules are enforced. It was, I think, kind of surprise to the Glendale mayor and council that the Independent Ethics Commission could be handling a complaint brought by one of their citizens and not a process that was dealt with locally. But that is the case until you sort of occupy the field as a home rule municipality. You know, if you're not going to play at all and not have rules, then the Independent Ethics Commission defaults and you're subject to their jurisdiction. Or more accurately, you're subject to their jurisdiction until you take an action to have your place, put your own rules in place. So that inspired me in that case, which was decided, I think, early this year, in favor of the mayor because the court held that Glendale had, in fact, adopted an ethics code that, while not the same word for word as the constitutional provision, addressed reasonably fully the same topics. And in fact, that was one of the issues in the case as well. He didn't address it exactly the way the Constitution does, and so therefore the Independent Ethics Commission still has jurisdiction. The court said no. No, the whole point of giving home rule municipalities the ability in the Constitution of having their own rules was that they could have their own rules so long as those rules generally occupied the field. So that's the background against which I've brought this matter to your attention. I have looked at the city's charter, and those provisions are really very, very narrow and don't, I think, begin to address kind of the range of things that the Independent Ethics Commission has jurisdiction over. And I would more than question whether if the similar complaints they were filed against Councilmember Keeter, the Independent Ethics Commission, on some sort of you've received this money from someone that might potentially influence you, whether our charter here would be enough of a defense for me to say, well, we occupy the field, because the charter provisions are really pretty narrow. So for that reason, I've given you this background and the suggestion that I have, and many home rule cities have done this, have chosen to adopt a local ethics code that largely tracks the Constitution. Number one, for jurisdictional purposes, and secondly, I think for probably three reasons. One, so that you can have that jurisdiction that the courts have said you have, and that the Constitution, when the voters approved it, said you can acquire for yourselves by local action. Secondly, so that you can make the rules that are specific to this community. And the Glendale case is really instructive for that purpose because, and I'm glad that the argument in front of the court was, well, it's not exactly the same as the Constitution. The court said, no, that's not the point. It doesn't have to be. You're allowed to have a local approach so long as it covers these matters. So that's available to you, and I've made some suggestions we'll talk about in a second. And the third, and I think as important issue is, well, who enforces that code? Of course, Glendale was not happy that they would have to go down to the Independent Ethics Commission and have a hearing down there. Up to you, of course, you could choose to not act, in which case I think the Independent Ethics Commission would have jurisdiction over that imaginary complaint I cooked up against or about Councilmember Keeter, and thanks for being willing to be the example. Same here. In any event, what I have done is made some suggestions of what might be appropriate for the city. It's frankly kind of an amount, looking at the Constitution under one elbow, making sure that we're addressing the matters so that you benefit from that. The court saying you've got to be in the arena of these particular issues. Number one, and number two, making some local changes, and lastly, on enforcement. Let me just point out for you what I've suggested anyhow as an amalgam of what other cities are doing, again with an eye on the Constitution, and also a suggested enforcement tool, and I'm happy to take questions. One of the first things that the Constitution does is bans the gifts to basically public officials. It started out at $50. There's an inflation automatically built in every 4 years, and so I think it's at $59 now. But in any event, the Constitution defines what gifts are and what kind of gifts you can't, as a public official, receive. Money, forgiveness of debt, loans, rewards. There's some travel with some exceptions, promises of future employment. These are and then there's a series of exceptions. And one of them, of course, is campaign contributions. And that's clear in the Constitution, should be clear locally. Sort of minor things, a plaque, a trophy, admission to a reception or meal where you are participating as a speaker or presenter are carve-outs. Travel when it's official travel. And that, I think, was the vagaries of that was the complaint against the governor, Hickenlooper, if I'm remembering right. In any event, I've put together at the bottom, I think page 2, some suggested language for a Wheat Ridge Ethics Code. First, a gift ban, that no officer may accept a gift if you have control over which would affect or improperly influence your job, your public duties. Obviously, we all receive gifts from our friends and our family. At least, I hope I'll get some gifts from my family at Christmas, and that's perfectly fine. I'm a public employee, but I'm still allowed to receive gifts, and that's fine. Is the nature of that gift one that would influence my duties for the public, or which would be a substantial economic benefit? And then there's this long list of carve-outs you'll see on page 3, which is tracking the Constitution. One of the things that is carved out that I wanted to particularly mention, I think, was the gift of the ability to participate in number 6, items of perishable or non-permanent value, including meals, lodging, travel, to sporting, Broncos tickets. That's not in the Constitution. It's something you can carve out, or is something you can leave in. I wanted to draw special attention to it because that's something that is either fine or can be abused. And you have complete authority locally to decide that that's going to be an exception or not. But the others are largely track the statute. If you turn the page, there's 2 other topics to be addressed in such a code that I would recommend. Conflicts of interest And this very much tracks the state statute, which applies to you and has for a long time. But again, the state statute doesn't help you vis-a-vis the Independent Ethics Commission unless you have, as a home rule city, your own local system. So you'll see that you shouldn't engage in employment that would conflict with the discharge of your official duties. You shouldn't have substantial financial personal interest in a transaction with the city. And you may not disclose confidential information to further your own financial interests. That's pretty standard. It's largely tracks the state statute. It's pretty standard approach. Then there's the appearance of impropriety, which is a little harder to define, but you shouldn't do things that call into question the propriety of the government you're working for. Bringing us to the last point I want to make, which is enforcement. The letters A through F here, the bottom of page 4, are again an amalgam of what other cities are doing. Importantly, they place the council in an enforcing role. And that's, to the extent you have anything in the charter, that's true in your charter already. You could certainly appoint some other body or some person or some hearing officer. But I've long believed that, especially for matters like this, it is elected officials that are in charge of policing themselves as a group. And I'm not recommending that it be some other party. And most cities will make that the job of the elected officials themselves. So a couple of things that aren't under the IEC's jurisdiction, but you find in ethics codes: nepotism. Don't be in a position to supervise or pay for or get records on a member of your family is really what that is. And campaign finance, I don't recommend any changes on campaign finance. We have a good statute on campaign finance. It's well understood. I work with the city clerk every time there's an election in the city, and I think that system's operating really well. And so I don't really recommend campaign finance in any kind of city ethics code. You can choose or not choose on nepotism. That's not something that the Independent Ethics Commission has particular jurisdiction over. So those are the topics, and I'm available for questions. I suppose the going in question is, do you want to have a local city ethics code for either the reason I describe, which is to assume jurisdiction rather than having the Independent Ethics Commission take that jurisdiction, or for some other reason? And if you do, what should be in it? The outcome, of course, will be, as it always is in study sessions, consensus direction to me to either bring forward an ordinance that tracks it in part or in some other way, or not. So that's what I can tell you.
Okay, thank you, Mr. Dahl. I'll open this up for questions from council. We have questions. Mr. Keeter.
Thank you. I was just wondering whether some of the other ethics codes that you look at, do they at all deal with like categories of punishment or consequence? I mean, obviously as attorneys, censure,
Yeah.
All the way to disbarment.
Yeah. I haven't seen that, interestingly. That's a really good question, but no, they haven't sort of said for this kind of offense, minimum sentencing guideline, or sentencing guidelines, for lack of a better way of saying it. No, possibly for the reason that these issues sometimes can be, highly political, and just having a set of guidelines like that constrains the discretion of the body. But I have not seen that.
If I may,
Yes.
a quick follow-up. I assume there are probably other parts of the code or charter that would potentially, if using disbarment as the example, that in a ethics hearing, I'm sure there are other limitations that would prevent the council hearing an ethics complaint from ejecting somebody from their seat on council, for example.
Yes, and I if this conversation goes further on that line, I'm going to need to grab the charter and remind myself about removal. But it's rare, of course, for there to be discipline by the council of council members. But
It was more a framework question than something that I think necessarily needs to be answered at this moment or necessarily needs to be dealt with
fair enough.
in the ethics code, just an acknowledgement that there are probably some other constraints on what those actions could be.
That's true, and I will say Amendment 41 doesn't go there at all, which means that you're welcome to go there or not and still benefit from the occupy the field, the authority that Amendment 41 gives home rule municipalities.
Mr. Matthews?
I had questions similar to Councilman Keters over there. How do we frame enforcement without having some kind of guideline? I mean, could we even try them to say that someone has to resign from their seat? Well, they're an elected official. How do we kick somebody out of their seat? Is there a fine? Do we come up and say there's a fine of $100,000 for what you just did? I mean, I'm just not sure how you would. I agree there should be enforcement for everything. If there's a do not do, then there should be, or else the consequences are. But how do we go about framing this in this particular instance? I think we need a little more discussion on that.
Well, I can make a couple of suggestions. I know absent Amendment 41 entirely, and over my career, every now and again, pretty rarely, but every now and again, there's a complaint against an elected official that's serious for whatever reason. I remember being kind of helping the Oak Creek Town Council years ago on whether or not to vote to remove. But in preparing for those few times, they come up in my practice once every few years, really, so not very often. In preparing for that, I've always kind of, I try to find three doors, three options. And one of them is you have the hearing, and maybe there's there's an ascending level here, so stay with me. One is you have the hearing, and that by itself it's political, it's public, and it's an impact on that elected official. That's the lowest level, but it is an impact. You can't say it's not an impact. But I said, stay with me. The next level would be some form of letter of reprimand. And I've seen that suggested as well. Now, clearly that doesn't take someone out of office, but I think you would have the authority to enact an ordinance saying, based upon an ethical complaint that we've now decided we're going to handle ourselves, one of the tools available to us would be a letter of reprimand. And you see that occasionally. The U.S. Senate once in a great while will vote to censure one of its members, and that's the next step up. After that, maybe suspension of some privileges. I agree with you that I think you have to be really careful about disenfranchising the voters who put someone in office. But local or municipalities in Colorado have the power to remove their members. They do, and in a minute we can look at the charter, but I know that's true, and that's an extreme remedy, which in a rare case could be available. Every single case I've had to deal with, written charges are, that's a common tenet. If you're going to consider rejecting someone, you've got to have written charges and an opportunity to be heard, a little hearing, and you have that hearing. In all of the cases that I've been involved in, it's stopped short of removal, and it has been either, this hearing was painful enough. Have we learned the lesson we were going to learn here? And, people learn that way, or censure. But you do have the power of removal. We would want to make sure that, and let me answer another aspect of your question in a sec. If the council went forward with this, we'd want to make sure that the enforcement process that you do by ordinance here, and that's the only way you would do it, to put it in place, recognized the power and limitations on that power for removal that's in the charter. And we would do that. I think I would not advise that you set up some kind of schedule. If this is the sin, then this is the punishment, because I wouldn't advise that for the reasons I described. And each case is so unique, you know, in its own way, that I think you would want to wait until you'd heard the case really to know what the right thing to do was. And you wouldn't want to spell it out ahead of time, although I would be perfectly comfortable saying in the ordinance, here's the range of things that are available to the council based upon what it learns through the complaint process.
Let me give you an example. I remember having a conflict with a state engineer when I was on a highway project, and he said, well, yeah, I know I'm wrong, but I'm a member of the union. They can't fire me. The worst they could do is put me on a night overlay job, and I like those. So, I mean, you know, he could be censured by his boss, but there was really no consequence that went behind it. And I'm not one that's in favor of being particularly punitive that way, but if we're going to have an enforcement code, I think it should, I don't know, I mean, you hear about guys getting censured in the federal Senate and stuff, and they just, 20 years later, they're still there. I mean, you know, it just had no impact. So I just don't know where we fall in this. Like I said, I don't want to be punitive, but something's got to have some meaning somewhere too.
And I absolutely agree, but I think you'll agree with me, or at least I haven't heard disagreement, that you don't know until you've seen that case. And frankly, given the person their day in court in front of you, because a complaint that comes in we all know there's more than usually two sides to every story. And so there's a complaint. This person did this, or I was, you know, had this conflict or whatever. And you have the hearing, which the law allows that council member, that elected official, and you learn more. And I don't disagree that you shouldn't have the tools. And I think you and I are in agreement. I think you don't say ahead of time, for a conflict of interest matter, it's this.
No, I agree. I'm just saying, I just don't know how to, I'm looking for more explanation from you on how we would, unless you're going to bring it to us, you know, in the form of the amendment or something, but how would you, in our code, how would we, what kind of language would we expect to see in what you bring forward to us on enforcement?
Here's what I would try doing. You've got sort of the outline down here and on about page 4, but in terms of consequences, I'd say something like, if the council determines after the hearing that the matter is not frivolous and that a violation of this code has taken place, the council comment in consideration of the severity of the offense, the mitigating circumstances, if any, the aggravating circumstances, if any, the statements of the council member, him or herself, the testimony of the public hearing, may take any one of the following actions. Then a list. No further action. You know, again, the range. No further action, public censure, consideration of removal of the council member. And that's how I'd articulate it. Because now you have a structure, and until you have an actual case that walks in with its own, you know, characteristics, I'm not sure you do more than that, but that gives you a structure, and it tells you kind of what you're thinking about after you've had the hearing. Okay, well, it was not good, but the person said, I was completely unaware here, and this caught me flat-footed, and I'm owning this. You know, that's very different from from some other fact pattern, and as the judges, you would take that into account.
Additional discussion or questions? Ms. Hoppe.
Whoa, we nailed them down there.
Thank you for this memo. On page 3, under C5, the one thing that that I can think of that often come to us are tickets for like fundraiser dinners and school fundraisers And those tickets are sold to the general public at a face value, and sometimes that face value is like more than $59. So would that be covered under item number 5? I just want to clarify and make sure that something like that is covered. I know oftentimes the point of having the council members come to those dinners is just so that the school community can feel engaged and involved, and the parent community of the school can feel engaged and involved, and sometimes, perhaps hoping that of course, extra seats in the chairs, there's, more people bidding on silent auction items and stuff like that. So I just want to make sure that that's covered under that.
Yes, in 2 ways. You'll notice item number 6 doesn't have a value associated with it, and the Broncos tickets, I don't know, I haven't gone to a game lately, but I bet you they're more than $59. So number 6 is kind of irrespective of value. And let's remember that this whole list of things is a list of things not considered gifts of substantial value. Go back up to the top of that page. You can accept a Maserati, which has substantial value from your best friend. The trigger to get into this whole system is that it is a gift from a person interested in a public matter over which you have control, which would and that gift would tend to improperly influence you. And so, let's remember that we all have lives, and people give us gifts, and it's perfectly fine. It's just the narrow category of gifts from a person interested in a public matter that if you received it might tend to improperly influence you. And okay, now you're in the arena, and then those are suspect. Then within that category, there are exceptions, and that's this long list. So it's a long way of saying, yes, I think that the fact pattern you describe probably doesn't even make the first cut up here. Is this a gift that would be from someone that's interested in a public matter over which you have influence, and the gift would tend to unfairly influence you? In that particular case, they just want you to come and help support and sort of show the flag for the city, but there's not probably an application or a land use case or something that they're trying to butter you up for. So I think for 2 reasons the fact pattern you raise is fine. If you get past door number 1, door number C6 also protects you.
Thank you. Mr. Keeter?
Just a quick follow-up on that. Isn't there possibly even one more gate that it doesn't pass through? A lot of, at least so far my experience, a lot of those reception seats and such are actually things made available to the city that the city then makes available to us. Does it even qualify as a gift out of the gate?
That's not a gift from a person interested in a public matter. That's an internal, congratulations, here's the gift, says Patrick Goff, and the good news is it's a gift. The bad news is now you've got to go to the dinner. And it's all part of your job, sorry. Absolutely, yeah, I think that's true.
And one other just quick question, that we can, if we adopt this, we have the opportunity to tweak it and work it, but
Absolutely.
But the idea from the start is if we want to assert local jurisdiction, we've got to get something on the books.
That's correct.
And we
yeah.
can fine tune it as we need to
Exactly.
based on experience.
What we have is just not enough, I think, to pass muster under that Glendale case, and we're all kind of grateful that Glendale, made the law for us. And they made the important law that it doesn't have to be exactly the same, but it needs to occupy that arena. So absolutely, it'll be in an ordinance format because it won't be a charter matter, and so you would always have the ability, as you're constantly tweaking the land use code, you'd have the ability to tweak this.
Thank you. Mr. Urban?
Thank you, Mr. Mayor. I think on the whole, the first section regarding gifts and gratuities, I think, is well within the lines of what we need to do. As it relates to conflict of interest, there's already 2 different sections in our code that reference conflicts of interest. It appears they're the exact same language, but they're listed in 2 different places. So I would be opposed to inserting the conflict of interest section in this particular code of conduct because we already have that on the books. And then the appearance of impropriety seems next to impossible to enforce or otherwise engage with. Someone might appear to have a conflict of interest, but if there really isn't one, how do you adjudicate that particular case? So I would be opposed to inserting the appearance of impropriety because there's no real way to flush that out. And then as far as enforcement's concerned, the Glendale ordinance elucidates two separate violations. One is a letter of reprimand, and the other is any other disciplinary action that may be available. But I would prefer to be light on how we prescribe the penalties. I would obviously be opposed to removal from office because I believe the recall process already provides for that exercise if we needed to do so. But my overarching concern here is similar to Mr. Matthews in that as we look at this on the face of it, it makes sense that we'd want to call someone to task if they're operating unethically. But the practice here, this is, unless we do this carefully, this turns into a political tool overnight, and people can bring up frivolous claims. So one thing that I'd like to see in here is that any claim prior to being reviewed by council would be confidential, and if it's determined to be frivolous, that it continues to remain confidential so that we have some sort of ability to make sure that we're not just going through the motions for a situation that ends up being frivolous and now that person's name has been dragged through the mud. So that's a concern for me. And then if anything, if we could hone very closely to what Glendale has already provided, it's a very bare bones code of ethics, and in my mind it gives us what we need as a foothold to get started with this. But at the end of the day, my overarching concern about implementing anything close to this is the ability for this ordinance to be used as a political tool as opposed to actually ferreting out and finding code of ethics concerns. The one question I had for the city attorney on the point that Councilmember Hoppy raised about a dinner that I may attend or not. At what point do my roles as a city council member end and start? Because as a city council member, I'm only a council member when I'm up on the dais voting in a business meeting. And so which other times of the day am I to adhere to these codes of ethics? The simple answer would be all day, every day, but the hard answer is trying to keep track of everything that's going on. And, well, no, that's got nothing to do with the city. This might have something to do with the city, and this over here definitely does. So as far as these codes of ethics, what I don't want it to end up being is a investigation into someone's entire personal life when we're only dealing with the city here.
Fair enough, and let me respond. I think that's an absolutely fair question. The truth is, as you all know, you're council members 24/7, and that's when your phone can ring, and that's when you can get emails, and that's the job, as you well know. But having said that, that's, I think, why there's a value, and it's very subjective. The same dinner or the same gift or whatever it is could be truly a violation because you know why you're receiving this, because there's that case coming up. Or it could just be, frankly, a gift from the same person in a different month without that involved at all. So how do you sort that out? In part is what you're asking. I think that's why you have to have a frivolous complaint system. I'm glad Glendale has that. And I'm receptive to the idea of making those confidential. I would like to look, one thing I'd want to follow up on is whether and to what extent the Open Records Act intersects with that.
Wouldn't it be a personnel matter and therefore not?
Yeah, the trick about personnel matters when it's elected officials is there's nuance there, and I don't have the answer in my head, but I know where to look. So I guess my answer to the, gosh, how do you really know, is to have a good frivolous complaint process, because when your doors are open for complaints, you're going to get them, and you just are, and you need to be able to treat them honestly. I'm fine with I've never been wild about the appearance of impropriety, because it's, by its own definition, it's just a subjective world, and I just don't think the Independent Ethics Commission's gonna worry about that. On conflicts, I agree with you that we have conflict provisions in the code. 3.14 is, and the other one is they're the same. What they don't reach is number C, not disclosing using confidential information acquired in the course of your official duties to further your own personal interests. And I don't see that element in our charter provision, and I think it's useful. I think it's I have to advise you this. I think if you stick with your your charter on conflicts, I'm reasonably confident if I were to have to defend it on the Glendale model, I'd say, Your Honor, we occupy this arena. Not the same as others, but we've got a pretty healthy conflicts charter provision, and I'd be all right with that. But I am pointing out that our charter doesn't reach the issue in letter C, and that's available to you.
And I think that would be an appropriate addition to that, but my overarching concern when we have what would be now 3 different sections on conflict of interest is which one is the overarching tool to use. The first 2 conflict of interest statements mirror each other exactly, but I just want to make sure this is woven in there in such a way that we're not trying to compare 2 different two different types of conflict of interest when someone's faced with that.
Sure. Fair enough. I think from the drafting standpoint, not too difficult. You could say conflicts of interest is governed as to all elected officials by 3.14, as to council members by whatever the other number is. It's exactly the same. In addition, no officer or employee shall disclose, et cetera, and you could plug in letter C. And I think somewhere it can be either express or it's always the case that you can't do anything in the ordinance that would undercut the authority of the charter, but sometimes it's useful to say, and if there's any conflict here, the charter controls. That's true. It's just a matter of law, no matter if you say it or not. But I think sometimes it's helpful to repeat it in places like this, and be happy to do that.
Thank you. Ms. Hobby?
Thank you for that. I think with that, I'm going to try to find a consensus. I'd like to ask for a consensus for a creation of city ethics code, as suggested by the city attorney, with the changes under conflict of interest to add per charter, add the sections plus C, delete A and B, delete appearance of impropriety, and for him to come up with if we are able to do confidential, frivolous complaints and keep them confidential in his zoning or in the ordinance that he's drafting.
Ms. Dozeman?
So I just have a quick question. So what would be the review process? Kind of speaking to Mr. Urban's point of like, keeping it confidential. Is there a review process? Is that by staff? Is that you? Who would that be?
Yeah. I want to, as I said, I want to kind of go to school on it and see if I can accomplish that for you. But my first inclination is that the provision would say when a complaint is received, it's and I don't want to be I don't want the city attorney's office to be in the position of making any decisions around it other than it's reviewed by the city attorney to determine if it fits within the scope of the system itself. If it does, then possibly the initial, is this frivolous, not frivolous review might be able to take place in executive session under legal advice on specific legal questions. You know, we have a charter provision, as you're aware, that really limits your ability to have executive sessions more narrowly than the statute, and I'm perfectly fine with it. In all the years I've been here, it's worked perfectly well. I think that category would apply here. And so that's kind of my first idea about how to make the council conversation around, well, is this frivolous or not? We're going to dismiss it out of hand, or is it going forward in that arena? I want to look at the Open Records Act, though, too, to see, okay, you have documents, obviously. You know, somebody writes a letter, a citizen writes a letter and says, I think, you know, poor Mr. Keeter here, he's a good sport. You know, that document itself is not, you know, that's an open record. It just is, unless there's an exception in the Open Records Act, and I'll look, but I rather doubt it. Your action on it in a attorney-client session might be protected under the Open Meetings Law, but the document itself, and maybe if you determine it's frivolous, it'd probably require a motion in a regular council meeting. Say, we received the letter from citizen A about this person, and we're determining it's frivolous, and you take a motion. That's probably public. I'm struggling to find a way that all of, you know, can come in and it can be determined to be frivolous, and it just doesn't go anywhere.
Right.
You know, hard to do.
Thank you, Mr. Mayor. I can't really speak to that as to how to navigate that, but one of my concerns as we walk through this is, in that executive session, is the defendant present during that executive session? Because that person shouldn't be allowed to vote on whether it's frivolous or not, because they'd say, oh, absolutely.
Yeah.
You know, so they couldn't be present in that executive session, that they shouldn't be allowed to vote on it. And I guess the other question I have is, do they receive legal representation from CIRSA in this proceeding, or how are they represented in this matter? Or do they just kind of go with what they got?
Typically, no. We've had it since I've been city attorney. We've actually had, I think, a long time ago, a mayor suing the city, and that was that was not a CIRSA defense. You know, the CIRSA represents the city and its officers, etc. But in this particular case, I don't think so. I mean, that's a good question for CIRSA, and I'm happy to ask them, and I will.
Acting outside of their duties?
If they're acting outside of their duties, typically no. Clearly, a little research is warranted here, especially around the degree of confidentiality that you can layer in here. If you're not worried about that at all, to be blunt, it's a lot more simple, because it is. But I'm mindful of the concern you raise, and I'm not lecturing at all when I say that's also kind of part of that's part of the job too, is those kind of things. And I think there's going to be, I'll look at within the bounds of the law what you can do. But I think it's going to be a lot more limited than a personnel action of a city employee, for example, who has the legitimate, in my opinion, expectation that personnel action and their personnel records, et cetera, are pretty confidential.
Mr. Matthews?
Thank you. On the face of it, I would be against dropping the appearance of impropriety without doing something then, because that would take out this quasi-judicial process as being unethical, and would that show up somewhere else? And I have a secondary question on quasi-judicial. Are we digging ourselves a hole when we have council people as liaison to other agencies that will eventually have issues coming before us in a quasi-judicial format?
No, I draw a distinction between the quasi-judicial rules of the game and the things you need to worry about and the things that, cause problems, and a conflict of interest arena, because the conflict of interest arena is typically financial and personal interest in an outcome that would help me as an elected official. Very different from the rules that I must follow in maintaining a fair and impartial decision on a land use hearing. And sometimes they intersect a little, but I must tell you they don't intersect nearly as much as it sort of sounds on the surface. That's what I'm not particularly concerned about. I think it's possible and to be able to make distinctions between those two. Clearly, they both affect the rules of the game for elected officials and how they must behave, but they're really two very different kinds of behavior. And I don't, while there's lots of problems sometimes raised in quasi-judicial matters, it's not a conflict of interest matter per se, and I'm not as concerned about that.
Ms. Hoppy, or just a minute before I go to Ms. Hoppy, Mr. Keeter.
Sorry, just very quickly, on the confidentiality, is there any confidentiality right now before the independent commission? Or is that a public hearing that whatever we can do is going to be an improvement in that direction?
I don't know the answer to that, but that's a good question. That might be that's a good place for me to start in the research to try to address Councilmember Urban's question. I try to have the answers to all the questions you might possibly ask before a study session, and sometimes I'm successful, but I'm to the point in my career where I know when to say I don't know, but I know where to look. That's actually a good starting point in terms of possibly how to structure it for the city, although the IEC is not a home rule city, and I did a little bit of work on the IEC when it was first formed, and my recollection was that their information was pretty open, but I never had to attend a deliberation, for example, and kind of see, okay, what do they do? Do they hear people, and then do they go away and deliberate and come back? And that'd be useful to know. I'm happy to check.
Our counselors work diligently to try to come up with questions that they might stump you on.
Yeah,
And,
impressed.
So, Ms. Hoppy, would you like to take another stab at a consensus?
I am, thank you.
Thank you so much.
I'd like to ask for a consensus for a creation of a city ethics code with the suggestions made by the city attorney, with the exception of deletion of the conflicts of interest, referring to charter sections that speak to conflict of interest and adding item C, deleting appearance of impropriety, and creating a process for determining frivolous complaints prior to hearing and enforcement with available confidentiality means available.
Show of hands. Looks like we have a consensus on that. 4-1.
Fair enough. Thank you.
Okay, thank you very much.
Mr. Mayor, could you please, for the sake of the clerk, take account on that 4-1?
Yes, that was,
With Councilman Matthews not.
Mr. Matthews was not in the consent, not voting affirmatively on that item.
I usually don't, I have the 4-1 down. I usually don't identify the negative votes. Would you like me to in this case?
In this case, please.
I will do that.
Thank you. We will go on to item number 2, rezoning protest procedures. And Mr. Dahl, are you leading us through this also?
I am, and this one's only 2 pages
Please
of
continue.
text. So this is a little easier to describe and was mentioned at the citizen comments as well. You're fresh from a series of cases where there were protests, so you're familiar with the structure of what we have. There's a charter provision that addresses rezoning and allows owners of property within the area to be rezoned, adjacent to the rear or any side or across the street for 100 feet. And if you're across the street, you pretend the street isn't there for the purpose of measuring the 100 feet. So that if the street's 100 feet wide, that would disenfranchise the people across the street. So you pretend it isn't there, and that's how you draw the zone around the area where a protest is permitted. I mentioned that this protest provision is mirrored in city-initiated rezoning in the code of laws in Chapter 26, but the charter is really what controls here, and that's where it always comes up as individual rezoning requests by individuals. And once a protest is received, that kicks it up to a 3/4 vote of the entire council, so 6 votes for passage. I know that because it has received attention, that the charter says that the protest has to be submitted to the council no later than the hearing on the proposed amendment. And told you in the memo, while over the years I've been consistent in saying that I think fair interpretation of the charter provision is that they can come in during the hearing, as long as you're not done with the hearing yet. I think that is what, that question probably wasn't asked when the charter provision was written, 1984, but I think that's the way to apply it, as opposed to, gee, you've got to have filed your protest before the start of the hearing. It would be good, but I don't see it in the charter language, and my additional reason for that is, what's the protest process about? It's a citizen protesting a rezoning. How does that as a neighbor and property owner, how do I know that's even happening so that I can access my right to protest? Well, there's a notice, and there's a posted notice, there's a published notice, the notice on the website of a hearing. So I say, okay, by gosh, I'm going to go to the hearing, and I see I've got a right to protest, I'm going to show up. To me, it's intimately tied up with your right to show up at the hearing and say things. And one of the things you might say, if you're in the right zone and close by, is that you protest. So I feel that's what the charter says and requires, and I've consistently suggested that that's it. When occasionally we do get protests ahead of time, which is great, and those can be in the council packet. And if you have questions about that, I'm happy to take them. Let me go to the second page, and then you can have whatever discussion you like. This came up, I think it was Councilmember Hoppe that raised it or wanted it to be discussed, and because, as was mentioned earlier, when there's a protest, it does change the dynamics, change the voting requirements, sometimes triggers additional discussion. And I have said, and the question is, can we do anything about this? And you'll notice I've given you the standard word on doing ordinances that address charter matters. You don't have the power, you simply don't, only the voters do, to change the charter, and you don't have the power to enact an ordinance that unwinds a charter granted right. You absolutely have the right, and you've done it a bunch of times. Every other ordinance you adopt implements the charter in some way, and I've given you examples. All of Chapter 26 is implementing the charter power to rezone property. All of Chapter, whatever it is, 7, I think, implements a very short provision, the charter on elections. So yeah, it's kind of your job to implement the charter, so you have the right to do that. You have to be careful around making certain that ordinances do not conflict with the charter or undercut a charter power or right or limitation for that matter. And so with that in mind, and with that kind of limitation on your power around doing an ordinance on protest, I came up with the 3 bullets I came up with as things that you could do. You do them now, and you have that power now kind of on a case-by-case basis, and just recently you chose to, I think, continue the hearing, have more testimony, and I can't recall on that one matter whether it was continued for action only, I think it was. So there's no preference here. I've just given you the things that you do, and over the years that I've seen done, you can keep doing that. And you don't need an ordinance to do that, but if you want to ahead of time sort of signal to people, if this happens, this is what we're always going to do, then you put it in the code, and you have the right to do that. And in my opinion, none of these 3 bullets violate the law or rule I described earlier, which is none of them undercut the charter power, by gosh, to submit a protest before the end of the hearing and trigger 6 votes. That's true under each one of these 3 bullets and hasn't changed at all. And I feel strongly about that, as you can tell, because I feel strongly about the fact the charter has to control. So you can keep moving as you do now, or you can pick one of these doors and say, and put it in code that that's what we're always going to do if a protest comes in. We're always going to vote. Or I doubt that. If you're going to do something, I doubt it would be number 1, but I want to give you all your choices, and oddly enough, there are 3. If you receive the protest and you've closed the hearing, continue for action. You're always going to continue for action, so you think about it. Or you'll continue the hearing. And importantly, I've pointed out that if you continue the hearing, then the hearing's not over, is it? And if the hearing's not over, then there is the ability for additional protests to be filed, understanding that the area within which protests can be filed is not big, and it's probably less likely you'll get one, but you might. So those are the choices I can think that you could put in a code provision, or you could have a healthy discussion about it and say, we don't think it's broken, the system works, we receive protests, it occasionally means that it's a 6-vote requirement, sometimes we continue for action because we want to think about it. That's all available to you, it's completely appropriate, and you've used, over the years, the councils have done each one of these things. So, I don't have no recommendation on this one. I had a recommendation on the Glendale matter, but no recommendation on this one.
Okay, questions of council? Mr. Keeter.
On the, as you said, if we leave the hearing open, there's the potential for more protests. Isn't protest pretty much a binary, that if there's a protest in week 1 and then it's continued 2 weeks later and there are more protests, multiple protests don't change the standards, do they?
No, they do not, no.
So as long as there's the one
Good
in
point,
place, it really,
Yeah, all it takes is one, and then you're there. Yeah, that's a good point, actually.
Well, it's one, don't you need 20% of the adjacent landowners to make a valid protest, or did I miss something?
No, you didn't. You do, but you could have had a protest on the north side, and that triggered the 6-vote requirement, and you say, okay, we're going to continue the whole hearing, and then you get another protest, potentially, on the south side or across the street, because the fact that, I think Councilmember Keeter makes a good point, the fact that you received a protest, if the hearing is still open, doesn't mean that someone else says, yeah, I realized the first guy triggered a protest, but I want council to know that I feel this way too. And they've got every right to do that.
Ms. Hoppy?
Thank you. Thank you for this information in this memo. You know, the second option after receiving the protest and having closed the public hearing and then continuing the matter for action, unfortunately, I don't feel like really, it doesn't help in the situation of allowing citizens to have the opportunity to be heard if there is a protest. And so when we close a hearing and then continue it for action, the hearing does not get reopened. We take no more citizen comment on that. So for me, I think that we should enact an ordinance amending the code that when a protest is filed, and they have until before the hearing is closed, so while the hearing is opened, then we can continue the hearing to the next business meeting. And when it's continued to the next business meeting, when it's continued and not closed for action, then everybody would be able to come and have, they'll have their opportunity to come and speak, and for the citizens to be heard. So I think that utilizing this to implement the charter through the code in this way, I think is a good way for our citizens. Oftentimes we hear, I didn't know, or nobody told me, or I didn't see the notice on that meeting. And I know that we try really hard to make sure that we get all that information out, but sometimes there are people who just don't get that information. And so this would give them an opportunity, and it also gives everybody a fair playing ground, so everybody knows the rules, because somebody may not know the rules about the protest. They may know that there's a hearing going on, but they may not know the rules about a protest, and so then that's kind of like a surprise. And so just making sure that everybody can be on equal ground, I think, is important, and I think that was it was the reasoning behind asking to add this to a study session.
Additional questions or comments? Mr. Urban?
Thank you, Mr. Mayor. I personally think we're we're good with what we have, and that the desire to postpone a vote or the hearing based on the presentation of a letter of protest, in my mind, is trying to find room or space to be able to get, to allow someone to get in front of that property owner or protest holder, whoever it might be, and try to change their mind in one way or the other. And at least as council members, if this hearing is continued, we still are within that quasi-judicial veil, so we're not allowed to communicate it or talk about it, but that wouldn't prevent a developer or someone else from communicating with a property owner who's filed a letter of protest and convince them through a variety of different ways as to why they should rescind the letter. And so one of my concerns is that if that type of ordinance were to go forward, I would like to see at least something in there referencing the process and procedure for rescinding a letter of protest, if at all possible. I don't know if that implements the charter or restricts it, but if we're going to allow time between when the hearing occurs and when we vote on it, we need to have some pretty clear rules around what it takes to rescind a letter and how long they have to do so, and when does that letter sort of stick, as opposed to sort of oscillating back and forth. Is it a real protest or is it not? Did they file it or did they rescind it between when the two hearings occurred? So I think, as this memo's pointed out, we have all these options at the present time, and depending on the situation, it may merit postponing to a future date, but in my mind, I think we have what we need in the current code, and there isn't any overarching need to change what we're doing.
So I just wonder if our attorney, so as Councilmember Urban asked, like rules to rescind a protest, so can you go over the process currently that there is?
Well, it's the charter's silent, as we know, on that. I have given thought to that in anticipation of this meeting, and I think that you could write a rescission process into the code for rescission of protests, where the charter is silent, and if what you're doing does not injure a charter right, I think that you could do that. There's no question. We've just recently learned the charter is silent, and so you have to make a judgment around what you think that silence means, and I have done that, as you well know. I am perfectly fine with articulating that in the code, and I think if it's articulated appropriately, such that it doesn't influence the filing or not filing of a protest. That's the key. You know, there's a citizen right to file that is inviolate, and that's what you've got to make sure, no matter what you do, that you don't mess that up and that you don't create improper incentives. But I think that's the drafting that's possible to do. It's a procedural issue when you think about it, just as it's a procedural issue about filing it, before the end of the hearing, and it's procedural in a sense to have to measure 100 feet, and how do you do that? And the charter has procedures for those things. It just doesn't have a procedure on protest. It doesn't have a lot of procedures on elections either. It says we got to have them, and then you go to the code for all the procedures. So as long as you're not denying elections when you adopt the elections chapter, similarly here, I think that you could write that.
Thank you. I wanted to make sure that we were clear, particularly to our viewing audience, that a protest may or may not be just a single property owner, depending upon the percentage of property, I guess, that's owned. Can you go through a little background on what constitutes the property owner or owners of the adjacent properties? I mean, is that, how do you, I guess, are those individual, is it one person, one vote, or is it, how do you vote property?
It's the owners of the area. You'll notice the charter language is that a protest may be filed against the rezoning change by the owners of 20% or more of the area. adjacent to the rear or any side, or of, quote, the area directly across. So if you've got a square property, or you've got odd-shaped properties, it's trickier, but we've had to do it in the past. It's the area. So if you have, let me think if I can actually depict this. Okay, you've got, this is the property being rezoned, the square in the middle. You draw lines that radiate out from the side to figure out the top, who can protest here. You draw lines that radiate out from either of the sides of the property and that go north-south. And, okay, now you go out 100 feet, and that's the rear of the property, so we want to have a street here. Go out 100 feet. If the property is 100 feet long, you've got something 100 feet by 100 feet, so whatever the math is. How many square feet is that? Thank you very much. Okay, good. So that's an area, and the charter is specific in saying the area. In the event of protest, change assigned by the owners of 20% or more of the area. So you've got 10,000 square feet. 20% of 10,000 square feet is? Thank you. Okay. I went into law because I was never going to go into math. So you need the owners of 2,000 square feet within that 10,000 square foot area. If there's one owner, sure. If it takes 5 owners to get that, that's fine too. We've had in the past here, to have to take a recess because the ownerships were multitudinous on that one side to see if there were enough.
This includes the people that are within that 100 feet of the corners of the property that's up for rezoning, correct?
Well, you draw the areas radiating from the sides of the property. That's what the charter says to do.
That's a length. You need to have another measurement in order to get an area.
You do. There's the length and there's the width. The width is 100 feet. The length is as long as the side of the property is.
But what about the people that are on the corners? That's what he's asking you. You're omitting those from your calculation.
Well, we stick with what the charter says, and we don't try to color between the lines. And let me read it to you. In the event of a protest against such changes signed by the owners of 20% or more of the area of the property, easy, of the 20% of the area of those immediately adjacent to the rear or any side extending 100 feet from the property. So you have to be immediately adjacent to, let's say, a side, extending 100 feet.
So it wouldn't include the property across the street.
Yes, it does. That's number 3. Of those directly opposite across the street from the property extending 100 feet from the street frontage of such opposite property. As I mentioned when I began, you're not punished by virtue of the fact that you're across the street and the street's already 100 feet wide and you're out of luck. You pretend the street isn't there and you pretend your property line is adjacent to the property being rezoned and you go in 100 feet. And in practice over the years, sometimes that has meant that it's an entire person's lot. Sometimes it's meant it's only the front half of their lot. It doesn't matter, because you're not doing subdivision here. It doesn't matter for purposes of determining whether they're an owner in that area or whether you get enough the ownership of 20% of the area. And we've had to recess the hearing, in my experience, and go and look it up and check. They don't have to be contiguous to one another. If one person's got 5% and one person's got 5% and they don't touch, and or someone's got 15% but they don't touch, you add them together, and that's signed by the owners of 20% of that area. And that's what triggers it.
Thank you.
Yep.
Ms. Hoppy.
Thank you. I'm going to ask for a consensus, but before I do, I want to just clarify, because the consensus I'm going to ask for is from bullet point 3. Therefore, the procedure would be, we would open a hearing. We would either start that hearing or accept a protest just before that hearing or during that hearing. Once a protest has been entered and accepted, the hearing then gets continued to the next business meeting prior to any further testimony. And then, once it's continued, then everybody has an opportunity for more testimony? Or do we continue the testimony, get to the end of all the testimony, and then continue it?
Up to you. From a drafting standpoint, the way the present bullet is written, I guess, I hadn't thought about that subtlety. From a drafting standpoint, you could do either one. You could, and here's what you'd say. Upon receipt of a protest, immediately upon receipt of a protest that is determined to be valid, because sometimes you have to go check, and there have been a couple times where we've checked and the ownership just wasn't 20%, the council shall immediately act to continue the hearing to the next regular business date, at which time, there's another alternative in a minute, at which time the remaining speakers shall be heard and any additional testimony at the continued hearing shall be taken prior to the council taking action. That's one way of doing it. Or you could say, upon the receipt of a valid protest, the council shall complete the testimony of all persons wishing to testify at that hearing, at that time, on that date, and then shall act to continue the hearing to the next business meeting at which any person, and I don't think you should have a rule saying if you testified 2 weeks ago, you can't, again, that rule's hard to enforce, and you could, but I think there's a kind of a due process issue there. If you're going to have the hearing open, other people are going to talk, okay. That's how I would articulate it to accomplish either goal.
Okay, so I don't think that it's fair that, like, if in the middle of the hearing we get a protest and then we tell everybody else that are here that day that they can't deliver their testimony because maybe they won't be able to come to the next business meeting. And so again, trying to make sure that this is equal ground for all. I'm going to ask for consensus on rezoning protest procedures that are enact an ordinance amending the code that when having received a protest, the council will continue the hearing to a later date after all testimony has been completed for those who are there for testimony at that date, and it will be continued to the next business meeting. Also, that we will look, that the city attorney will work on guidelines and rules for the rescinding process once a protest has been filed.
Question, Mr. Matthews?
A couple of comments. If I could, before we go to consensus on this, what is your take, since you're taking a very narrow view of the geometry of the area of protest on a curved property line? What side is that?
I don't know. I'm trying to recall back when we've had more odd-shaped, dimensions. I just,
because I
don't know.
I'm concerned that we maybe need to delineate on that a little bit and bring some clarity, because if they've got a common corner, they are technically touching that side of the property. And so I wouldn't want us to make a decision here that would start something in motion. I'd like to get a little further clarification on that, since we're talking about that. Also, I had the question that I never quite got to, but what's the process for reopening a hearing, and is that possible?
Let me take up your first point and then go to the other one. You raise an absolutely fair point. For a completely square, you go, well, what about the corner? And here's what I'd like to do. I don't think that there was an intention to disenfranchise that property owner, because they touch at an infinitesimally small point, but they touch, and if you go in 100 feet, there's some real live dirt there. Do you draw an arc? And if so, which 20% are they part of, right? Here's what I'd like to do for that. Several times I've had to help evaluate multiple small parcel protests, and we've drawn little maps in the recess to kind of figure that out. I'd like to sit down with ComDev and look at some example properties and draw some maps. I certainly don't want to disenfranchise. The charter, the way it's written, on its face kind of does disenfranchise, which isn't good. You have to dig a little bit and say, did they really intend to disenfranchise? Because the charter has the power, bluntly, to disenfranchise. If they'd said this is all it is, then that's all it is, no matter if you'd like today to have more. That's all a way of saying I understand what you're saying, and the concern you raise, I think, is absolutely a legitimate one. Let me see how we've addressed that in the past. I'll bet we have. Secondly, with respect to not continuing the hearing, but your second question was to...
Yeah, I would be more in favor of, what I'm concerned about is, we just had a recent dust-up because we closed a hearing and then we continued, and then people now have becoming aware of the situation, wanting to come in and talk and testify. So if we get to that point where we think that usually if we're going to continue something, it's because there's been some point of conflict or something unexpected has happened.
Yeah, you want to do
And we've already closed the meeting and then new information or something happens. So then everyone comes to that next meeting a week later, but all of a sudden we say, oh, you can't talk because the meeting's closed.
As I hear the proposed consensus, proposed consensus, as I hear it, is to make clear that they can, and that the hearing is not closed and is instead continued.
And I'm asking, is it possible to reopen a hearing?
Oh, I see. Separate and apart from this consensus, is it possible?
Well, yeah, I want
Yeah.
people to be able to speak, and that's what I'm asking. Last time we had closed the hearing,
Right.
and then we moved forward, and filled, the
Right.
place was packed with people that
Okay,
were now aware
I
of the
get it.
situation, and we couldn't reopen the hearing, or didn't. I don't know which.
Not without additional notice, because in a rezoning case, you have to give notice of that reopened hearing. And the law is clear, that is done all the time. That's why you have hearings, quote, continued, because if you're able to, while it's still open, if you continue it, the law is that is notice to the world that they can still testify next time. If you close the hearing, and then it's 2 weeks later, you can't just kind of on your own reopen it. You have to have preceded that with new notice.
Could you reopen it on the same night? Right, if you've closed it and something
I
comes
see.
up, everyone's there, could you reopen it on the same night?
No, and here's why. There's a Cherry Hills Village case, believe it or not. They had a hearing, and they told the applicant, okay, we're going to close the hearing, or the opponents, everybody go home, we're good. And then they reopened the hearing later that night, took testimony from, I think, the applicant, additional testimony, and approved the application, and no good. And even if you can't tell that anyone left or didn't, we're also on TV, and in my experience, people have seen part of a hearing and have come in, having seen it on TV, and come in to testify. I think that's wonderful myself, but that's why you can't do that in the same night.
I'm just in favor of continuing and keeping it open so that people
Yeah.
can have their full chance to be a part of the process.
Mr. Keeter?
So one question on the corners. If the charter says that the people on the edges have the right to protest, but is silent about the corners, would we have the authority to grant that right to protest to additional people as long as we're not conflicting with what the code, what the charter allows?
I think for that, I would want to look at the legislative intent, and I would want to go back to the 1984 adoption and look at everything I possibly could, and here's why. Where you're drawing a diagram, and you say on this, you've got dimensions that you can see, that means whether you meant to or not, that you have given rights within that diagram and not elsewhere. And I don't think if it was clear that that's what was intended, then under my earlier, statement about you can't change the charter, then you can't broaden rights either if they were not granted by the charter. So I'd want to look, because the charter's silent, because if you took just a square, on their face, the people in the corners are kind of out of luck, but I would want to look carefully at the legislative history to be able to give you a basis to say that that clearly was the intention. And then you enter into kind of dangerous territory where something's pretty express, and you go, yeah, but the intention was probably something else. And the rule of statutory construction, as you well know, is that if it's clear on its face, you don't get to legislative intent. I'd want to look, and you can see I feel less confident about that. At the same time, on its face, it looks like it should be fair, but sometimes things get written and they aren't, and if they're written in the charter and they aren't, well, that's the remedy isn't an ordinance saying, well, we're going to do this anyhow. The remedy is amend the charter.
I know there are different takes on things, but one definition of adjacent to is touching. So that's why I was asking you for you to do some research on the legalese of
adjacent to a side. It doesn't say adjacent to a point, but is that point, the point is part of one side,
yeah. So
or another.
What I'm saying.
Yeah.
So
Yep.
do a little research.
A point
that
can
way.
be a side,
Okay.
We'll check. I know where to go for that, to learn that.
Okay. And Mr. Keating, you got a follow-up?
Actually, this is a separate question about the consensus. Are we proposing that this happens in any time a protest is filed? Because I could see a scenario where if a protest is filed sufficiently ahead of time, such as, and just spitballing, if the protest is filed in time for it to actually show up in the packet, that then we wouldn't necessarily need to automatically delay things for 2 weeks.
I think for it to be fair, it should be any time, meaning even if it's ahead of time, that it should be any time. Now, of course, that does leave it open for more people to file a protest, but that doesn't mean every protest, it gets continued and then continued. So I think to be clear, we should say anytime it's filed, that then happens. Because it's also part of that notification that people not everybody reads the packet. And so when we're on TV and we say, okay, this will end up being continued because there was a protest filed, then people who are watching or listening or who catch up later on in the week will then know that had happened. So do I need to reword the consensus anyway? Okay, so I'm asking for
If you
the
could
consensus.
clarify that again.
Sure. Asking for a consensus on rezoning protest procedures, and that we enact an ordinance amending the code that when a protest is received, City Council will complete the testimony at that date and then shall continue the hearing to the next business meeting, and that the city attorney draft rules and guidelines around how to rescind a protest once it's been filed.
So we have, let's see, may I see a show of hands? Okay, we have a 4-1 consensus on that.
Okay?
Okay, does that conclude item number 2? You have your direction on that?
It does. I've got
Okay.
my direction. Thank you.
Thank you. Then we will go to agenda item number 3. This is the 2019 Liquor Code Amendments, and I think you're on the docket for this one too, Mr. Dahl.
I'm on deck. Third time's a charm.
The hat trick here.
Yeah. And now for something completely different, as Bullwinkle would say. See, people laugh at that. People know about that. That's great. I love that. You have a memo to you from myself and Jane Greenfield, who you were pleased to meet, I think, and who worked through carefully some of the other liquor code changes. The legislature was pretty active and did a bunch of stuff, and that resulted in a need locally to make some changes to our liquor laws. The list of things on the first page of the memo, with the exception of the last bullet, are things you've already told us to do, and so we're doing them. And so I'm not asking you to revisit those. Those are all, Councilmember Hoppe consensuses, and those were all approved. But they're useful to know that we're separating lodging from entertainment for the purpose of the 500-foot, and we're exempting lodging uses from the 500-foot separation from schools requirement. That's going to come up later. We said lodging's a Class G operator. Entertainment types are Class T. That's all about what kind of fee they apply for, or they have to pay. And so we're drafting the ordinance that does all that stuff. Pretty mechanical, really, leaving us with the a couple of issues that are detailed on the next page. So if you go to the next page, there's really 3 questions I need to ask you and get your direction on so that I can determine, include those in this kind of one-size-fits-all giant liquor ordinance. Yeah.
Can I ask that we take them one at a time?
Oh, yeah, absolutely, I intend to. Yeah. Oh, okay, I get it. Yeah, in other words, presentation, take them. Yeah, fine, good. The first is one that we've got probably, well, the first one is, it came up, as you might recall, we had a discussion, we were pretty close to, I thought the council was pretty close to saying, yeah, liquor store employees really ought to have, or liquor stores really ought to have a 21-year-old supervising, with the elimination of the distinction between 18 and 21 for 3.2 beer, that sort of put the question in front of us, and council was pretty close. And then there was a little discussion kind of toward the end, you might recall, where it was, well, how's this going to affect primarily convenience store operators that, sell beer, but we do have, some small liquor stores that have, and others that have younger employees, and should there be a requirement that you have a 21-year-old supervising? It's completely within your control, and so you get to decide this one sort of social policy. But you might recall that the output of that discussion was, let's ask them what they think. Let's ask our licensees what they think. And in your packet is the letter that was sent, and then the few responses we did get, and I assume everyone has seen those. There was a response from Pester, that has gas stores, right, that sell beer. There was a response from Ryko Coast Pizza, and there was a response from Joy DeMott that isn't on the 21-year-old supervisor issue. It's on the school separation it's on question number 2. So you've got 2 liquor licensee types that are saying, to summarize, and you read them, we trust our, we've got training programs in place, and this is an employment resource we need for our business, and we'd rather not have that requirement, and that's our request. You see in my little memo to you the number of stores that are affected. It looks like we've got 16 liquor stores and around the same number of grocery convenience stores. So pretty straight up question for your decision.
Hoppy?
Thank you. So my question is, in your memo, you said there's 16 retail liquor stores and 16 grocery convenience stores. Those all would be affected if we changed it?
Yes.
Okay. And then in the letter from Pester with the, they have the convenience stores.
Mm-hmm.
He says that if we do that, then it would be in contradiction to the state liquor code. Is that true, or is that a misunderstanding?
Yeah, I think it's a misunderstanding. There's really misunderstanding of what you're allowed to do. You have the right to make that decision locally, and while for a state-only license, maybe yes, but I.
So for the state,
Yeah.
currently, they're allowed to not have to have a 21 or over supervisor on premise.
Yes, that's correct. So you get to decide if you're going to require that.
Okay.
And so in that sense, yes, it's contrary to what the state would let you do, but you're the local liquor licensing authority, and in this particular arena, you've got that discretion.
Okay. I personally am leaning towards not adding that language to our code.
Mr. Keeter?
Mr. Dahl, you mentioned that this is ultimately a social policy question, but the memo includes a recommendation to add language to the code. Is that, I guess, one, is there a specific legal basis that you think that this change should be made? And also, are you and, I'm sorry.
Jane.
Are you actually making an active recommendation by the phrasing of this memo?
I appreciate your asking the question. No, not really. I was kind of reflecting what I thought we almost got to when the council, had the discussion earlier. I don't feel strongly about it. I actually sort of get the concerns of the industry here, so I don't have a strong feeling. I think it was Councilmember Pond that said, as a part of that discussion, you might recall, well, gosh, if they're selling liquor, I think, if it's 21 to drink it, I think you ought to be 21 to sell it. But but I don't feel strongly about it, and you can, I'm perfectly fine with that recommendation being ignored if you wish.
Mr. Matthews?
I'm not particularly interested in, I'd have to see how we define that. For instance, when I was in high school, I worked in a restaurant, and principal business was, selling food, of course, but during my senior year, he took on a beer license, and so I had to go get an adult waitress to deliver the beer. So it just didn't make sense to me, but at the time, but also a lot of the smaller establishments and some of these small liquor stores are family run too, and does that preclude them leaving their 18-year-old son, daughter, whatever, in charge? And I'm just not sure that we need to get this pushed in, but that was just two examples I could think of. The construction industry, OSHA has rules allowing owners' kids who are very young to work in the construction industry, apart from the normal course of things.
Fair enough.
Ms. Hoppy?
Unless Councilmember Urban has something particular to say on this, I'm going to move for consensus to not follow.
Before you go into that, and I appreciate you reaching the consensus, but one of my concerns about this is trying to look at the holistic approach of the reason why we have a liquor licensing authority, and do we know whether or not the liquor licensing authority has had any violations or other cases brought to them regarding a licensee's revocation of their license or any other kind of violations or other actions that the liquor licensing authority has taken in the past few years?
Around this issue?
Or any issue?
I'm not aware of anything. I don't know,
Janelle, has the liquor... Sorry.
I'm sorry, I didn't hear the question. I was typing and reading.
I was curious as if the liquor licensing authority has had any disciplinary cases or other issues brought forward to them regarding a licensee's actions or behaviors.
Not as far as the younger people selling. It's more, occasionally there is a service to minors.
Yeah.
But that's not what you're talking about here.
Well, I guess my overarching question was that is our liquor licensing authority bringing forward any kind of regulatory actions or disciplinary actions against any licensee, and what patterns are those? Is it, like you said, serving to minors, and that's the majority of our issues?
Oh, no question, it's either the three categories, because I'm in front of the Liquor Licensing Authority on and off, service to underage, service to visibly intoxicated service after hours. You know, there's still beer on the bar, it's 10 a.m. kind of thing, and you've got, those are the things that have triggered the most enforcement actions they've taken.
Okay.
So,
Mr. Donnelly, in this analysis, do you make a distinction between liquor stores that are permitted to sell vintners, you know, and I don't know if it's liquor, you know, wine and liquor, and convenience stores? They have a different liquor license to sell fermented beverages, but not liquor.
they do. For this purpose, in terms of, are we going to require a person 21 or older to supervise, I'm not making a distinction. You're absolutely right that if you've just got an FMB license, you're not going to be able to sell whiskey. But, and I could go back to, could look at whether we could make a distinction between, okay, you got to be a 21 to sell liquor out of a retail liquor store, but only 18 to sell. But that's, presently, that's not the question posed.
And sort of hasn't been, if I understand,
Yeah.
because we used to have 3-2 beer.
Yeah.
And that sort of is how
Yeah.
convenience stores
Yeah.
and grocery stores
Yep.
sold
Yep.
beer, fermented
And that's why we're in this
And
spot.
that's why we're in this now.
Yeah.
But in the questions and the analysis that you've done, you haven't made a distinction between selling because if you just have a fermented beverage license, you can't sell liquor, can you?
No, you can't sell liquor. You can sell now stronger beer.
Right.
And all sorts of iterations of stronger beer.
Right.
Correct. That's correct. Yep.
Ms. Hoppy?
I'm going to ask for a consensus that we do not add the language to the code section 1153 as suggested by the memo from our city attorney on this item. Do not, sorry. Do not,
Do not require a 21-year-old supervisor.
do not.
So we have consensus, we have unanimous consensus on that issue.
Excellent. Thank you. The second of these three is and the third also deal with the separation requirement from schools, and you know what that requirement's all about, so I won't have to explain that. The state liquor code, when they revised it, created this new category of lodging and entertainment, and I've spent a lot of time with Ken Johnstone on this, and also Robin Eaton, trying to work our way through, well, okay, what's lodging, what's entertainment? Earlier in your prior discussion, you said, we're not worried about a lodging use. You know, you've got a bed and breakfast or whatever, and you're serving some alcohol. We're not worried about that if it's within 500 feet of us. We're not going to apply the 500-foot separation requirement to that kind of use. And the question reserved for today is, well, what about entertainment uses? And there's all sorts: galleries, theaters, arts and crafts classes, bowling, golf. And I spent some time with Ken Johnstone, and he said, you know, it's going to be impossible for us to sort of create, in the land use code is not the place to decide, okay, oh, you're a bowling alley. Okay, now we're going to decide if you're within 500 feet of a school. Oh, you're a golf. Oh, okay, now that's okay, and bowling alleys aren't. And the sense is this, that and this is one where I am making a recommendation, the sense is this, that the kinds of lodging and entertainment uses that are conceived of in this new state category, which they wrote without really thinking about how local zoning codes read, frankly. This is, I believe, a solution in search of a problem, and I don't recommend that we get into the business of trying to determine which entertainment uses can't be within 500 feet of a school. I really believe that if this turns into some kind of problem, that the city in the future is not precluded from addressing it, but at the moment it's, to begin with, it's very complicated to sort of, okay, that bowling alley, no, but this golf, miniature golf, whatever, is entertainment. And frankly, we have right now hotel and restaurant licenses that can be within 500 feet of a school, or not, your typical H&R license. You got a nice restaurant and you sell liquor, can be within 500 feet of a school. I think that the complexity of, once you're into the entertainment uses, there's a lot of entertainment uses out there that we will now preclude being within 500 feet of a school if you have any kind of broad definition of entertainment, and it gets worse from there. And again, this is sort of a non-existent problem, and the solution to fix it is complex. So that's my view on it. I've talked to Ken; he feels the same way about that.
Thank you. Questions, Mr. Keeter?
But again, just for clarification from the recommendation, you are recommending that we take action to clarify that these licensees aren't subject to the requirements.
That's correct.
So
Yeah.
it's not we're not doing something different, but we have to take action to accomplish that.
We do. That is exactly right, because the state has said lodging and entertainment, but we have our local option to be able to opt out, and I think we should. Thank you.
Ms. Hobby?
I'd like to ask for a consensus that we follow the recommendation from the city attorney to add lodging and entertainment facilities that hold lodging and entertainment licenses to the list of exemptions from the 500-foot separation from school requirements in section 11-53. Add definitions for lodging facility and entertainment facility to section 11-51 for consistency with state definitions.
Consensus, unanimous consensus on that? Do you have another subpart of this?
I do.
Part three, so
We're-
this is the hat trick,
It
hat
is.
trick?
You're doing great work here, and I appreciate your hanging in there on these kind of ethereal questions. So now we have a different animal, and that's businesses that manufacture liquor, but only receive their licenses from the state liquor authority. And this isn't a liquor licensing issue, it's a separation issue again. If you're manufacturing liquor, should you not be located within 500 feet of a school, and you can exempt them by city ordinance, and the law allows, just like we just did. And you see the kinds of places that can manufacture and then sell, and really think a tap room or a sales room associated with a distillery maybe. But typically, if it's a manufacturing operation, it's industrial. And from just a zoning standpoint, would be only permitted in our industrial district, or maybe C2, and that's unlikely, frankly, to be near a school. We think that and these manufacturing facilities can vary in terms of their volume and size, and we think it's going to be difficult to pick and choose as amongst them for separation requirements. And I believe the comfort that we should take is we have zoning rules for industrial type uses that are largely going to move these uses or constrain them to industrial areas to begin with. And secondly, we do recommend, as you see in the recommendation, that the liquor, that we certainly can, these are state level licenses. You don't get a local Wheat Ridge license to manufacture liquor. It's not available to us. So it's a state license anyhow. So our role is potentially twofold. Saying, yeah, we know you don't get a state license, but from a land use standpoint, you can't be within 500 feet of a school. That's one tool. And we're recommending that's not, that our sort of standard zoning is a better approach for that. The second thing that we can do, however, is have the liquor authority refer any sales room applications to community development for comment. So we at least can comment to the state who is issuing the license to manufacture liquor. Here's how we feel about this particular location from a sort of a community impact standpoint. And I don't think we're going to get a lot of liquor manufacturers popping up in the city. Again, if we do and it becomes more of an issue, we can address it. But this whole arena is a little new, honestly. People sort of figuring out, how to manufacture liquor and what volumes, and it's new and okay. On balance, they're both for this and I think for the prior question about lodging and entertainment. There's value in supporting small and local businesses that would locate in the city and have employees, and not constraining them in terms of where they might be able to locate. And I think that's what Joy DeMont is saying in his email to you. That's the issue. I think at most we add a provision in our licensing code, Chapter 11, to refer these applications for comment. Questions?
Thank you. Questions, Ms. Hoppy?
So I had to pull out my old packet from the study session in January, or not in January is when it was done, but in February. And in that, it was reported that alcohol manufacturers such as microbreweries, distilleries, wineries, and their tap rooms have been permitted by right to locate in C1 industrial and mixed-use zones within the city. And so the recommendation then was to have them be viewed as special use rather than as permitted use when they're within 500 feet of a school. So this recommendation has changed, and I just want to ask what was some of the discussion that went around, or why did you decide to change it to just send the referrals to the Director of Community Development instead of starting a whole special use permit process?
Fair enough. That's a fair question. I sat down with Ken Johnston, and we talked about the review criteria for special use permits and kind of what those are used for in the city, and the special use permitting process, which is in the code, as not being particularly relevant to these kinds of operations which are industrial in nature. And you just usually don't have special use permits for a one kind of industrial use. And upon reflection, we felt that it would require kind of a different special use permit set of review criteria that really aren't served well by our existing special use permit system. And after having that conversation, we said, well, all right, what's broken here? We have zoning that says where industrial manufacturing operations can locate for the protection of our community generally. Shouldn't that work for this kind of manufacturing operation? And I think the outcome of that discussion was, yes, it does. Now, understanding that it doesn't service the 500-foot requirement, but that's a separate decision you can make, but you can make that separately from whether you require a special use permit. But we came out of all of that saying, for the couple of these operations that we get, they're going to be appropriately located from a zoning standpoint. Are they really a threat to school children, that there's that kind of manufacturing operation versus the next kind of manufacturing operation? They're manufacturing alcohol, but it's not. Why is that different? And we came to the conclusion it really wasn't.
Thank you.
Additional discussion? Yes, ma'am.
Mr. Mayor, I wanted to, by way of example, to inform council that if you're, I understand the whole industrial area kind of thing. The one that we have right now that I'm aware of is Rickolee's. They get their license from the state. We don't issue that one. So that's an example of the kind of license you're talking about.
Thank you. And Ms. Soppy?
I'm going to ask for a consensus that we add a provision to section 11-53 for the Liquor Authority to refer any state applications for liquor sales rooms to the Director of Community Development for comment.
We have a unanimous consensus on that. Does that conclude your
It does.
questions and activity on agenda item number 3?
I appreciate all council's help. I'll get right busy. Thank you very much.
Thank you very much, Mr. Dahl. We will now go to staff reports, item number 4. Mr. Goff.
Nothing this evening, thank you.
Okay, nothing from that. We'll go to elected officials' reports, and since I'm always hard to see the city clerk behind me, who sometimes has something, I'm going to go first to Ms. Shaver. Do you have anything tonight?
No, maybe just to say that it's getting towards election season, and we already have a couple of people who have filled out intents to run for city council. So if you're interested, you can look on the city website or call the clerk's office.
And those intentions are posted on the website?
I think they are. I think Robin has that.
Thank you.
He-
Thank you.
I can't touch the website. So,
Okay. Any information, elected officials matters that any of our counselors? Ms. Dozeman.
So I just wanted to congratulate the city on the reopening of Anderson Park. We had our official ribbon cutting this last Saturday. We were able to take tours of the Anderson building and see some of the improvements to the park, and got to sit in the new pavilion. So if you haven't gone out to see it already, go check it out. And I do want to notify the public that Anderson, the playground at the park is going to be closed because they are going to be adding some features, including a zip line. So we're really excited about that, but unfortunately the park, the playground is going to be fenced off for most of the rest of the summer.
Okay, other public officials matters. Okay, well, I would like to, I also went to the Anderson opening. Great job. Thank you to our citizens for their support on the 2E bond project. Our Parks Director, I also went to Joyce Manwaring's retirement celebration, and she had a very good send-off, and I want to once again thank her for her work on our behalf. So with that, we will stand adjourned. Thank you.